5, which declares that the parties have, quote, reached the following agreement to resolve the present controversy, close quote, which it, like the title, describes as, quote, the controversy between Venezuela and the United Kingdom over the frontier with British Guyana. Article 1 further defines the controversy between Venezuela and the United Kingdom that the agreement purports to resolve as the controversy, quote, which has arisen as a result of the Venezuelan contention that the arbitral award of 1899 about the frontier between British Guyana and Venezuela is null and void. Them to Geneva in February 1966, as Professor Akhavan has recounted, in which they agreed at Geneva to resolve. None of these facts about the Geneva Agreement are disputed by Venezuela in its written submissions in this case. Beginning with its first article, Article 1, the Geneva Agreement sets out the procedures agreed by the parties to resolve the controversy over the validity of the arbitral award. The first three articles, Articles 1, 2, and 3, establish a mechanism by which the parties agreed, in the first instance, to attempt to resolve the controversy diplomatically through a mixed commission. By its text, Article 1 mandated the mixed commission to seek, quote, satisfactory solutions for the practical settlement of the controversy between Venezuela and the United Kingdom. Article 2 then provided that the mixed commission would consist of 2 representatives of each party to be appointed within 2 months of the agreement's entry into force. And Article 3 required the commission to issue interim reports every 6 months. But the Geneva Agreement does not end there after Article 3. Although the parties agreed to seek a practical settlement in the first instance, they did not presume that they would be successful, especially after 3 years of failed negotiations leading up to Geneva that had seen no narrowing of their differences whatsoever. To the contrary, they agreed at Geneva on another procedure to assure a definitive resolution of the controversy in the event that the mixed commission failed to do so. And this procedure was set out in Article 4. Article 4 is divided into 2 parts. It begins with Article 4.1. This provides that if the mixed commission has not arrived at a full agreement for the solution of the controversy within 4 years, it shall refer any outstanding questions to the governments of Guyana and Venezuela, and that the 2 governments shall, without delay, choose one of the peaceful means of settlement provided in Article 33 of the Charter of the United Nations. 2 key facts in regard to Article 4.1 are undisputed by the parties in these proceedings. First, the mixed commission did not arrive at an agreement for the solution of the controversy. And second, the 2 governments did not reach an agreement on a means of peaceful settlement under Article 33 of the Charter. Venezuela has helpfully confirmed these facts in its memorandum of 28 November 2019, which is at tab 6 of your folders. At paragraph 24, Venezuela acknowledged that the mixed commission created in accordance with Article 1 of the agreement exhausted the 4-year period granted to seek a satisfactory settlement of the dispute pursuant to Article 4.1 without achieving its objective. And at paragraph 32, Venezuela wrote that Venezuela and Guyana failed to agree on the choice of a means of settlement. But neither of these failures was able to prevent the resolution of the controversy because in Article 4.2, the parties foresaw that this very situation might arise and established a fail-safe procedure for resolving the controversy in the event of an impasse under Article 4.1. According to Article 4.2 of the 1966 agreement, which is again at tab 5, if the parties are unable to reach agreement on a means of settlement under Article 33 of the Charter, they are required to refer the decision as to the means of settlement either to an appropriate international organ upon which they both agree, or, failing agreement on this point, to the Secretary General of the United Nations. In regard to this aspect of Article 4.2, the parties agree on 3 more key facts. First, that they failed to reach agreement on an appropriate international organ to choose the means of settlement. Second, in compliance with Article 4.2, they did jointly refer the decision as to the means of settlement to the Secretary General. And third, that the Secretary General formally accepted the parties' conveyance of authority to him to decide on the means of settlement under Article 33 of the Charter, and he agreed to exercise the responsibilities confirmed upon him. The parties' agreements on these 3 facts are confirmed in Venezuela's Memorandum of 28 November 2019 at paragraph 32, which acknowledges their failure to agree on an appropriate international organ, and in the annex to that memorandum, which is at tab 7 of the folders, at pages 35 and 36. As shown on your screens now, Venezuela here confirms that because of the parties' failure to reach agreement on an appropriate international organ, quote, there is an unequivocal interpretation that the selection of the means of settlement will be made only by the Secretary General of the United Nations. And further, in a letter dated April 4th, 1966, the Secretary General of the United Nations, U Tant, accepted the functions attributed to him by Article 4.2 of the Geneva Agreement, considering that those functions are of such nature that they can be properly performed by the Secretary General of the United Nations. In addition to providing that failing an agreement on an appropriate international organ, the Secretary General would decide on the means of settlement of the parties' controversy, Article 4.2 further provided that if the means so chosen do not lead to the solution of the controversy, the Secretary General of the United Nations shall choose another of the means stipulated in Article 33 of the Charter of the United Nations, and so on, until the controversy has been resolved, or until all of the means of peaceful settlement there contemplated have been exhausted. And in relation to this provision, there are 4 more pertinent facts that are agreed by the parties. These will be addressed in greater detail by Professor Sands and Professor Pele. For present purposes, it will suffice simply to identify those facts. First, the Secretary General decided that the first means of peaceful settlement would be his good offices. Second, that choice and the Secretary General's authority to make it under Article 4.2 were not contested by either party. Indeed, they were positively accepted by Venezuela. Third, the good offices process took place and continued for 27 years under 4 successive Secretary Generals, but it failed to resolve the controversy. Fourth, after determining that the good offices process had failed to resolve the controversy, Secretary General Antonio Guterres expressly invoked his authority under Article 4.2 and decided that the next means of peaceful settlement of the controversy under Article 33 of the Charter shall be judicial settlement by the ICJ. These four facts are all acknowledged by Venezuela in its memorandum at paragraphs 33, 34 through 37, 48 through 50, 54, 67, and 69. With all of these facts undisputed, the question now before the court is this. Under the terms of the 1966 agreement, is a decision by the Secretary General choosing the court as the means of peaceful settlement of the controversy binding upon the parties, or are the parties required first to express their agreement with the Secretary General's decision before it becomes binding on them? A review of the Geneva Agreement's terms in their context and in light of the agreement's object and purpose makes clear that the answer to this question can only be that the Secretary General's decision on the means of settlement is binding upon the parties without the need for their further agreement. Article 4.2 states expressly that if the parties are unable to agree on the means of settlement or on an appropriate international organ to choose the means of settlement, quote, they shall refer the decision on the means of settlement to the Secretary General of the United Nations. This makes clear that the Secretary General was conferred with the power to make a decision on the means of settlement. What is also notable is what Article 4.2 does not say. It does not say that the decision of the Secretary General is subject to the subsequent agreement of the parties, or that such agreement is required for his decision to be final or binding upon them. The absence of any language subjecting the Secretary General's decision to the parties' agreement is conclusive in its own right, but it takes on added significance when it is compared to the text regarding other prior stages of the settlement process laid out in Article 4. For example, as underscored on this slide, Article 4.1 requires that upon the mixed commission's failure to resolve the controversy, the parties shall together, that is by agreement, choose the means of settlement under Article 33. Article 4.2 then provides that if the parties should not have reached agreement on the means of settlement, they must refer the decision as to the means of settlement to an appropriate international organ upon which they both agree. Failing that agreement, they must refer the decision to the Secretary General. In this manner, the parties to the 1966 agreement provided that whenever the agreement of the parties is required to advance to the next stage in the dispute settlement process, the agreement says so expressly. In this context, the only logical explanation for the absence of any requirement that the parties agree to the Secretary General's decision on the means of settlement is that this was deliberate. The parties' agreement was not required because the Secretary General's decision was intended to be final and binding and not subject to their subsequent approval. In fact, by agreement of the parties, the Secretary General was entrusted not only with the power to decide on the means of settlement, but with the duty to make a choice in order to resolve the controversy. Article 4.2 specifies that the Secretary General, quote, shall choose. The language is mandatory. It creates mandatory responsibilities for the Secretary General, as Secretary General Outant recognized in his letter to the parties of 4 April 1966. In that letter, which is at tab 8 of your folders, in both English and Spanish, he formally accepted those responsibilities, which he considered to be of a nature which may appropriately be discharged by the Secretary General of